Item number 60, Mr. Amrendra Narayan Rai for the petition.
Yes, Lord, Annexure 8 is the impugned order by which the certificate officer directed to pay rupees 1 crore 10 lakhs within 2 months, failing which warrant of arrest and confiscation proceeding will be
Appeal
issued.
lies.
Milord, the order is absolutely without jurisdiction and barred by limitation, Milord.
Don't we take all those objections?
Milord, earlier I have filed objection and my objection has been rejected without considering the.
And if you file an appeal, the warrant of arrest cannot be executed. That is also there.
Milord, in appeal we have to deposit 40% amount, Milord.
2
Milord,
of the Act.
Milord, in appeal, Milord, I have to deposit
Bihar and
40%.
Odisha.
Yes,
Bihar
Milord.
and Odisha public demand every act.
Absolutely
demand
barred by
act.
limitation, Milord, as per under section 6, because the certificate proceeding has been started after
All
9
those
years.
objections. Please,
But Milord, we have to deposit
please don't
40%.
relegate this High Court to the stage of an appellate court.
My Lord, because we
Commissioner क्या चाहिए?
this poor
आप हमें
petitioner.
कमिश्नर समझते हैं या आप हमें कलेक्टर समझते हैं? क्या
No,
समझते हैं?
Milord, because.
When those people are authorized to decide your appeals, you want High Court to do that? Their work.
Milord, in appeal, 40% amount has to be deposited, Milord. This is problem. Your Lordship may waive the deposit of the said amount. We will file appeal, Milord. 1 करोड़ का 40%, 40 लाख से ऊपर गरीब आदमी 11 साल के बाद proceeding even they cannot file money suit even after 3 years, Milord. I have not taken a single penny. Allegation is misappropriate. Transporting agent थे 11-12 में, and after one his work was found satisfactory and recommended for another year.
Yes.
And after he lodged FIR in 13 itself,
Yes.
and after 10 years he filed certificate requisition for certificate
Allow
proceeding,
you to
Milord.
waive the.
As per section.
That waiver can be done.
Statutory remedy available as per section
Initial
60.
deposit waiver can be allowed.
My lord, as per statutory rules, my lord, section 60, petitioners deposit 40% amount before filing the case.
But that is too cumbersome a condition.
Yes, Milord, this is
Either
problem.
then we will not find, because it has to be efficacious alternate remedy.
Fine.
Then only, if it is not efficacious, it is not there.
Petitioners file application under section 60,
What
my
you
lord,
say?
and file IA petition or supplementary petition before the authority, my lord, to exempt that clause, my
Authority has
lord.
no power.
Milord, if
That can only be by the High Court. That is there, that's one judgment of Supreme Court.
Yes, Milord, if my lord find in a similar fact, Milord, this honorable court said, allowed this writ petition in a similar exact.
Writ petition.
Yes, Milord, in
No,
writ
we
petition.
we will not entertain, we will first ask you to go there only.
Milord, your lordship may observe to waive this amount, Milord, because how can this petitioner, poor petitioner,
Right.
will deposit 50%?
Agree. Either.
60, my lord, 60.
इसी बंद करवाइए. The petitioner assails the order passed in subsequent proceedings by the collector.
My lord.
No, certificate officer, Milord.
Certificate officer is who? Additional collector or the collector?
Deputy collector, my lord.
By the deputy collector. Whereby the demand of an amount of rupees 1 crore 10 lakh 84,575 has been raised with stipulation to deposit the same within 2 months, failing which warrant of arrest and impounding confiscation proceedings will be initiated against the petitioner. Para. As per B&O Public Demands Recovery Act 1914, Section 60, appeal is provided against the said order to the collector. However, Learned Counsel contends that as per the second proviso added to Section 60, the year 1974, 40% of the amount determined under the section has to be deposited as a precondition for entertaining of an appeal. Which is too cumbersome.
My lord, one submission, my lord.
Para. Section 60 of the Act of 1914 reads as under. In terms of the second provision, 40% of the amount determined under the section or such amount as the appellant admits to be due from him, whichever is greater, is required to be deposited. In these circumstances, this court is of the view that such a condition may be cumbersome and cannot be said to be efficacious remedy for denying entertaining of the writ petition. However, considering the facts of the case, this court deems it appropriate to allow the petitioner to file an appeal exempting the condition of 40% of deposit. If such an appeal is filed, the same shall be heard and decided within period of 4 months.
Sometime fix, my lord, petitioners file appeal, my lord, and cooperate to appeal.
Within 4 months from the date of filing of appeal. The appeal has to be filed within period of 1 month from today.
Lord, in the meantime, they shall not take coercive action against the petitioner. In the meantime,
Appellate authority in terms of section 60 within bracket 5 has the power to stay the execution proceedings. An appropriate application may be moved by the petitioner for in that behalf, if he so chooses, which shall be decided on merits by the concerned appellate authority.
Lord, before filing appeal, they shall not take coercive action.
Why don't you file it by tomorrow?
Yes, my lord.
If you are apprehending arrest, and if you are not
Filing,
apprehending
Lord.
arrest, writ petition stands